Hello, and in my final video on recklessness, I want to discuss with you the present law on recklessness. Now, before we begin, let's have a quick recap of what we've said so far. In order to establish a crime, we need to show that there was actus reus, i.e. the wrongful conduct. And then we need to show that the state of mind of the defendant was guilty. This we called mens rea, and there are different forms of mens rea. The most culpable being intention, where your aim or purpose is to commit the wrongful conduct. The next one from that, which is slightly less culpable, is recklessness, and it's all about actively taking risks. And what we've seen so far with recklessness is originally we had something called the Cunningham test, which was a subjective test. What we used to do is we used to look in the minds of the defendant and see were they aware of the risk, and if they were, was the risk one which was justified to take. That's how we would establish it. However, in R and Caldwell, 1981, this all changed. Lord Diplock devised an objective test for recklessness, and he stated that would be whether A, the defendant did an act which in fact does create an obvious risk, and B, he has done it either without giving any thought to it, so i.e. turning a blind eye to the risk, or knowingly committing the act even though he's aware and knows of the risk. So that's what Lord Diplock said. And for so many reasons we saw in the other video, this was problematic, it was unfair, it was unjust. So what is the present law? Well, in R&G 2003, the House of Lords, they returned the test for recklessness onto the subjective test as established by the Cunningham test. So let's look at the facts of R&G 2003. Well, essentially the defendants were 11 and 12-year-old boys. They went camping without permission, and they stole a newspaper from a store and they lit it in the bin, and the bin went on fire and the store went on fire, everything went on fire, and they caused criminal damage of £1 million, and they were charged under the old Caldwell test with reckless arson contrary to section 1.1 and 1.3 of the Criminal Damage Act 1971. They stated that they had expected the newspapers to burn themselves out, but not that the fire would spread and such damage to happen. And also bearing in mind they were 11 and 12-year-old boys. So the initial trial judge, he said the question was whether there was an obvious risk of property being damaged, which there was. And this is not going to be assessed on the fact that, like, look at their age, look at their characteristics. It's assessed on the basis of a reasonable man, as stated by Lord Diplock. They appealed, and then the Court of Appeal, they had dismissed the appeal because essentially what they said is that they were bound by the precedent of Lord Diplock and Caldwell. There was nothing we could do about it, even though it may appear that it was an unfair judgment. Then the House of Lords came in, and they said, actually, we're going to go back to the Cunningham test, and I'll explain the reasoning for it. And they said, so now a defendant is reckless where they were aware of the risk, number one, and two, they were aware that the risk would occur, and in the circumstances knowing to the defendant it would be unreasonable for the risk to occur. So you can see it's a subjective test. And then following the Attorney General's reference number 3 of 2003, the Caldwell recklessness was officially abolished. Now, what were the reasonings in R&G that caused this? Well, there were 4 main lines of argument. The first is they said the majority had erred in their judgment in Caldwell. They misinterpreted the word recklessly in the Criminal Damage Act because, as I was saying, it was clear from Parliament's intention with respect to the 1971 Act that maliciously was being replaced by recklessly without altering the approach of what is meant by maliciously or recklessly, which is a subjective test of what was actually in the defendant's mind. The second thing is they said it was just to depart from Caldwell. The injustice was seen in Ellen and C, as we looked at my other video, especially with respect to children. So on the grounds of justice, it would be fair to depart from the Caldwell test. Then they said, when you're looking at serious crimes, like this criminal damage one in R&G, it's a £1 million worth of damage. It's a serious crime. You need the defendant's state of mind to be guilty in order to make sure that the criminal justice system is working in a fair manner. Lord Bingham stated that the Caldwell recklessness infringed the important principle that a person was guilty of a serious crime only if they had a guilty mind. And also, there was no requirement of foresight in the Caldwell test. It meant that it blurred the lines between negligence, where you don't need foresight, it's all about falling below your standard, and recklessness, which is supposed to be to do with knowingly taking a risk as opposed to falling below the standards. And finally, academic and judicial criticism should not be ignored. The main people advocating so much criticism were John Smith and Professor Glanville Williams. The whole point of the Criminal Damage Act 1971 used the words intentionally or recklessly instead of maliciously. It did not want to change the subjective approach that the law had already taken. So that's the present law. We've gone back to the cunning and recklessness. And I hope this video helped.